issues surrounding marriage.
You are muted, please.
You chat. Sorry. Okay.
Good afternoon.
Yeah. Is it right for a fellow lawyer to say another lawyer is
Are you trying to unmute us?
Sorry, good afternoon, everyone. This is Mrs. Mr. Moderator there.
I can't seem, I think the moderator has gone out. Let me just introduce and we'll start off. Good afternoon, ma'am. Good afternoon, everybody. You're welcome to our inaugural webinar in this series. My name is Omolade Olomola, and I'm anchoring this committee on family law, succession and estate planning. Today, we would encourage all to mute their microphones so that we will have a peaceful time online. So that we can have a peaceful time online, we would encourage all of us to mute our phones and so that we can enjoy the proceedings. So this afternoon, well, incidentally, myself will be the lead speaker. Myself will be the lead speaker, and I have other participants, other people that will be joining me on this call. And we have Professor Nasiru Tijani as the first discussant. We have Mrs. Nancy Obinwa, who was the former chair. I'm glad that she's on call this afternoon. She's the second discussant, and we have Abdul Warid. And I want to first of all bring honor to whom honor is due by welcoming my section chairperson, our indefatigable Mrs. Folashade Ali, Senior Advocate of Nigeria. She's going to give a brief opening remarks as we continue on call. You are welcome, ma, for your opening remarks. She had to leave another meeting to join us, and we recognize this, and we know that our time is of essence here. So you are welcome, ma. You have the floor, ma.
Thank you very much, Chairman. Good afternoon, everyone, learned colleagues, and all our distinguished members of the bar and participants that have joined us from, I guess, various states in Nigeria and beyond. It's indeed my pleasure to welcome you all to this webinar that's been organized by the Family Law, Succession and Estate Planning Committee of the Nigerian Bar Association section on legal practice. First of all, while this committee has been in existence for some time, today really, for me, marks a first outing of this newly constituted committee under the chairmanship of Professor Olomola, ably supported by my vice chairman and friend, Professor Nasiru Tijani, and other members of the newly constituted EXCO. I'm also glad to say that this is a continuous one because we have the former chairman also here. So thank you, Nancy. Really appreciate you. This webinar for me reflects the commitment of MBA section on legal practice, especially the Family Law Committee, because we know it's very relevant. And I believe we're going to have an engaging day today. Family law, as we all know, affects each and every one of us. With the plural system that we have in Nigeria, from statutory to customary and Islamic law. It touches every one of us. So practitioners we are often, called upon to try and dissect, navigate, and try and look at the legal issues that affect each and every one of us. So today's theme for me, exploring Nigeria's marriage landscape, is very timely and practical. He invites all of us to examine the legal frameworks that governs marriage, the cultural context in which we all operate. And I guess it's not my job to be the speaker today. The committee task is very clear. I commend everyone, especially my committee chairman, our speakers, Nancy, Mr. Ibrahim, and I'm able moderator. I hope you come back on track, and Kambasha, and every member of the committee that's put together this session. I encourage everyone to please participate, engage, ask questions, share your perspectives. It's just the beginning of so many seminars that we believe we'll be having. And I just hope you all engage. And I wish you it's a very engaging, and practical discussion. But may I plead with everyone? I mean, this is a very I've finished, but I'm just pleading with everyone to please mute. I mean, if we want to have an engaging day, we all need to try and please respect and please, can we just mute if we're not speaking? The interaction is really destructive, and we can't continue to have a meaningful discussion this afternoon, except we all please stay muted. I mean, we'll try and change the platform going forward and make sure that it's not one where you can unmute yourselves. But please try to respect the rules today, and please be muted if you're not speaking. Thank you all. And have an engaging afternoon. Thank you.
Thank you very much, our session chair.
Thank you so much, Lynette Silka.
Please continue.
I think you can go ahead now. You can go ahead.
Hello.
Thank you.
Ugochi, unmute yourself.
Hello.
Yes, we can hear you. You were muted.
All right. Thank you. I just wondered how come. So I was saying thank you so much. Good afternoon. Please, if you're not
Ugochi, we can't hear you. You have to be unmuting yourself as they are muting everybody. We can't hear you, but I will start off. You have to unmute yourself. Okay. I think I will just start. So good afternoon, everybody. Without much ado, I want to go into the business of the day because we have quite a lot to do today. So, like I said, I would share my screen now, so that Okay. I hope that would see my screen and okay. I hope you can see my screen. Okay. So exploring marriage, Nigeria's marriage landscape. This afternoon, would be looking at the marriages that are legal, what we think are actually marriages, and the ones that are not marriages. I'm juggling the work of a co-host together with uh, just a moment, please. Okay. I want the system. I want you all to be able to follow. Are you sharing for your end? Okay. Just a moment, please.
Good afternoon, everyone. Madam Chair, Professor Olomola, you will be sharing your screen and we would follow with you.
All right. I was actually having some issues, but I want the screen to start from the beginning. Okay. Can we see my screen?
All right. While you're sorting out
Can you see my screen now?
We were seeing it before now, but we can't see it now.
We can't see it now?
No, it will show it again. We saw it earlier.
Oh, I will share it now.
All right. While Prof is getting ready with her slides, please permit me to make an introduction of who we'll be listening to as the lead speaker. Professor Omolade Olunike Olomola is a law teacher, legal clinician, and researcher with over 26 years experience. She teaches and researches in family law, clinical legal education, reproductive health rights law, gender equality, international humanitarian law, and refugee law. She's an author of textbooks and Family Law and Succession 2021 and Gender-Based Violence, Law and African Society. She's the head of research and documentation committee of the Nigerian Bar Association Women Forum, full professor and head Department of Private and Property Law, University of Ibadan. And she's the chairperson of this committee. Madam Chair, the floor is yours. We are
Thank you very much.
excitedly waiting to hear from you.
Thank you very much for the introduction. Without much ado, we want to go into what we have for today. I have barely 20 minutes, and out of it, I've done a low back and forth. Okay, so marriage is the foundation of any society. And when we talk about family, it starts from marriage. And that is why marriage is very important in the civil society. And there must always be this ad idem when we talk about marriage. There's the mutual agreement of parties, and marriage is such that creates a special status. Of course, this has been established by case law, particularly in the case of Attorney General and Fassbender, where it says that marriage actually creates status. And that is why you don't, because you have changed your jurisdiction or location, your marriage ceases to be. No, once you change your location, once you are married, you are married. And looking at marriage from Nigeria's perspective, you find out that people have contracted different kinds of marriages, but we derive our traditional classical definition of statutory marriage from the definition given in Hyde and Hyde, which says voluntary union of one man and one woman to the exclusion of all others. At this juncture, we need to know that marriage in Nigeria could be monogamous in nature and polygynous. What I mean by polygynous is what we'll loosely call polygamous. Polygamous is a wider term for multiple relationship, but what we actually practice in Nigeria when a man could be married to 2 or more women is polygyny. And so whatever type of marriage a person chooses will determine the incidence, will determine the nature of the relationship in that marriage, and will determine whether it will be a polygynous marriage or a monogamous marriage. Now, we have 2 types of marriage that are potentially polygynous but not necessarily polygynous. For example, we have the customary marriage. And when we talk about polygynous marriage, of course, a man may be married to one or more women, to the exclusion of all others, if you permit me to say that. So, and the mere fact that you have a customary marriage does not mean that your marriage will be polygynous. We have people that have married under the laws and customs that have only one spouse. So, but the nature of that type of marriage is such that you could have more than one. And polygyny is a customary law institution, and it is governed exclusively by customary law. Then on the other side, we have the Islamic law. But the caveat here is that under Islamic law, you are not permitted to marry more than 4. And even this more than 4, even this 4, there is a condition attached to it. Of course, when people want to go on their frolic, they will just say, oh, the Quran permits me to marry up to 4. But the condition attached to it, can they actually fulfill that obligation? Now, by its nature, the monogamous marriage is covered by the Marriage Act. We have the Cap M6 of the Laws of Federation of Nigeria, and we have Matrimonial Causes Act M7. And I need to reiterate the fact that marriage is exclusively covered under the legislative list, item 61, and that means that it's only the National Assembly that will legislate on formation, annulment, and dissolution of marriage. And that is why, till date, even no state House of Assembly can actually legislate on it. And all over Nigeria, if you want to file petition for divorce, it is through it's a petition. It doesn't follow the regular style of each court rules, as in this will be discussed in details in a subsequent webinar. But just for you to know that it is covered under item 61 of the exclusive legislative list, and it is the National Assembly that can actually determine what happens. So when you look at this broadly, you find out that we have marriage under the Act, We have marriage under customary law. We have marriage under Islamic law. And this is very common in some African countries like Kenya, Ghana, Sierra Leone, that operates this kind of tripartite system of law. And this tripartite system of law, we have not developed our own further, and is one of the major challenges that we are facing with regards to family law in Nigeria, because once you are not married under the act, people think that you are less married, and that is not supposed to be, because marriage under the act, whether you're married under the act or you have conducted a traditional marriage, or you have married done your nikah, you are not less married than, but it's just that because the law have not made a pronunciation, has not been codified, and these marriages are not properly and duly registered, people believe that it's only people that are married under the act are legally married. And so it has affected the way we view marriage in this part of the world. When we analyze the definition given in the case of Aidana that I cited earlier, you will find out that there are basically 4 conditions. Marriage must be voluntary. It must be for life. It should be heterosexual, which has ruled out same sex. And it must be monogamous when you are marrying under the act. When you are marrying under the act, no other person should be in contemplation. Let me quickly make some brief allusion to our tripartite system of law. This complex system of law reflects our historical development. And of course, before the intrusion of British and Islam influence, the various ethnic groups, they have their own autonomous system of customary law that governs marriage and all their traditional celebrations. But with colonization and advent of Islam, these variations came in. But till date, you find that elites still prefer the statutory marriage over and above customary Islamic type of marriage. And why this is so is because of the idea that one marriage is superior to the other. And it's high time we went back to the drawing board to correct this anomaly. Now, the type of marriage practiced in Nigeria are covered under Section 2 of the High Court of former Northern Nigeria 1963, which provides that customary law, which includes Islamic law marriage. Of course, we know that classifying Islamic law marriage with customary law is anomalous. It is not proper because one is codified, the other is not. When I say codified, I mean that Islamic law marriage follows the injunctions of the Holy Quran, whilst customary marriage depends on the customs of the people in a particular locality. And that is why the way the Ijaw people will celebrate their marriage will be different from the way a Yoruba man probably from Ibadan would conduct their marriage, and the same way the Hausa person will conduct their customary. So it depends on the custom of the people. Whereas Holy Quran is one. And if you want to marry under the Islamic injunction, you follow what is codified there. Just like marriage under the Act is covered by Marriage Act of 1914, Cap MC of the Laws of Federation. Still talking about this tripartite system of law because it has created a lot of acrimony within the system. The principles of law applicable to each, differ to a large extent on the different systems of court. And you find out that when there's an issue with a customary marriage, it's either they do what I loosely term pack your load and go, or they go to the customary courts. What I loosely term pack your load and go is the non-judicial mode of separation. It shows that our custom has not created any bottleneck for people. It's not that our custom would encourage divorce or dissolution, but what I'm trying to say is different from the regular court system of divorce that you file petition, reply, verify reconciliation, this. So this pluralism of marriage laws and dichotomy of courts, has created some kind of internal conflicts. And some people have married under dual system, all because they want to be sure that they are married. We'll still get there as we continue. But for a person to be actually married under the statute in Nigeria, there are some things that would show that indeed that person is married under the statute. The Marriage Act has provided under Section 33 that parties to a contract of marriage must have the single status at that time of marriage. And so these are sort of all ruled out situations where you will see a man that has married 3 women traditionally, now a small young girl that is educated, now says, oh, this is my legal wife. That person does not lack the capacity to go ahead and conduct another marriage under there, because there is no single status again. How do you want to do it? You already have 3 women, except he goes ahead to divorce them and then take up the new one. So the person must have a single status at the time of the marriage. However, I need to quickly state this, that a person that is married under customary law can still go ahead and marry that same person, in as much as there is no other encumbrance, as in there is no other person in the life of that person. The person can go ahead and marry that same person under the act. Then I need to also mention that the Marriage Act did not stipulate the age at which a person can enter into marriage, but the capacity of an infant to enter into a contract is usually governed by general law of contract, and that was 21 in those days. But I would want to say that with the advent of the Child Rights Act, 18 will be a reasonable age. But you see, the Marriage Act is silent. So you see, even the Marriage Act needs to be reviewed, because so many lacunae, are therein. Then parties must not be within the prohibited degree of consanguinity and affinity. Breaking this down, they should not be related by blood or by marriage. And the list is always in the first schedule to the MCA, apart from the social reason for this, medically it's not advisable for you to marry a person that you are actually related to. Although in time past it used to happen, but if you want to marry under the act, you shall not be within the same degree of consanguinity or affinity. Should not be related by blood or by marriage. Then a cardinal principle of our law is the fact that the parties must have freely consented to that marriage. Freely consented to that marriage, not that a marriage that you are stealing a woman, or all the Nollywood marriage kind of thing that we see, and they say they want to marry, and because somebody is my business partner, you have to marry. The parties involved must be addendum at the time of, they must have, they have the same mind, they must have agreements that they want to go into it. Then parties must be of opposite sex. So this automatically rules out same-sex marriage, like I said. And of course, the law since 2013 have criminalized same-sex marriage in Nigeria. So parties, the law will only recognize heterosexual relationship in Nigeria. And the way to go about this statutory marriage is, of course, by filing notice of marriage. A notice will be filed at the marriage registry that is in the locality of the couple to be. After the notice is filed, a registrar certificate will be issued. And of course, one of the parties should be resident within that district of the intended marriage at least 15 days prior to the granting of the certificate. And of course, there is no impediment of kindred or affinity. They have the single status. And the marriage must be celebrated within 3 months from the date of the notice. And failure to do this would render that notice void. They have to go and ask for another notice. Now, how do they celebrate this marriage? So that you will know that some marriages are not actually statutory marriage. You have not filed notice at the registry. You have not collected the registrar certificate. You now want to marry. Is if a marriage is celebrated, a statutory marriage could be celebrated in the registrar's office, and that is what is popularly known as court marriage. When they go to the registry on a certain day during office hours, there the marriage registrar would conduct the ceremony. There is no doubt about that. Once they have filed the requisite notice, there have been publication of bans. They have put the notice out there that, oh, Mr. So and so wants to marry Miss So and so, and there is no caveat. Nobody has raised any issue concerning the relationship. They can celebrate it. The second place where a marriage could be celebrated is a licensed place of worship. And when we talk about licensed place of worship, it's not every church that is licensed under the law to carry out marriage ceremony. A church that is licensed would have the marriage certificate of Nigeria in their custody. They have been so noted by the Ministry of Interior, Federal Ministry of Interior. And when you file the notice at the registry and you collect the registrar certificate, the reverend gentleman in that church would know what to do. Because when you now celebrate the marriage there, that's where they will now issue the marriage certificate in triplicate, where you'll be given two. One will be retained by the church. You'll be given two. One will be returned to the registry where you filed the notice within that district. If you have not done this, but your church has given you a beautifully decorated certificate that is even more beautiful than Nigeria's marriage certificate, ladies and gentlemen, you have just done celebration of church marriage. You have not done a marriage under the act. And of course, marriages could also be celebrated in Nigerian diplomatic missions. There are some people that are not within the country, but they would like to marry under our law. It could be celebrated at the diplomatic missions within the territory. And people can also get special license to celebrate their marriage. That's when they collect fiat and take marriage to gardens. And but the notice must have been properly filed before this is done. Now, making small allusion to the issue of same sex, because Nigeria, apart from the fact that Nigeria is a religious society with patriarchal favor, and our faith will not really permit such. People have raised the issue that, men marry for their husband. Is that no same-sex relationship? Well, when a woman has not been able to have a male issue or past childbearing age, cannot bear children for the husband, and decides to marry another woman when they say they marry, they use their money for the ceremony. It is not the woman that will be the husband. Although they call the woman husband, it is still the husband. So it's still heterosexual, but it's just a traditional cultural thing. So that one is not same-sex relationship in stricto sensus. It's just a cultural thing. And it happened some part of Igbo land among the Ishan people in Edo State, where a woman has not been able to give birth to a male child. Now, how do we have talked about how to celebrate statutory marriage. How do we celebrate customary marriage? Of course, depending on, just like I mentioned earlier, depending upon the milieu, as in depending upon the custom of the people. Some they would write the list, they would do first wine carrying, then they will now do the celebration. Of course, a key component of customary marriage is the payment of bride price. Some call it dowry, but of course it's not dowry, it is bride price. The parties will consent, and the families, unlike marriage under the statute that two people, once they agree and they are of age, they can choose to have witnesses and go to the marriage registry to file and marry even without the consent of their parent. But for customary marriage, there is dual consent, the families and the parties, to validate the marriage, and of course there will be witnesses from the community, the family, and it is usually celebrated in the cultural setting, and it depends solely on the custom of the people. And our legal system acknowledges customary marriage unions, and of course you are not less, like I said, you are not less married. The only difference between marrying under the act and marrying traditionally is the consequences, as an if you marry traditionally, the husband can marry more. As one, when you look at the evidence acts in cases of giving evidence in court, they see husband and wife of monogamous marriage, they see them as one. And like I also stated earlier, customary marriages are often polygynous in nature. And so, if you are married under that, it does not mean that you are not married. You are married, but it's just potentially polygynous. Now, let's look at how we celebrate Nikah. Nikah is a sacred bond between a man and a woman governed by Islamic teachings. And of course, there are some basic fundamental requirements for it. The first one is consent. Consent of the parties, is very essential. And the requirements, when we have the bride and the groom, there must be the existence of a marriage guardian. And this marriage guardian is someone that must be knowledgeable in Islamic law. And they are referred to as wali under Islamic Maliki law. And it could be a male relative or the girl's father, or it can, in the absence of either, it can be a Muslim malam. He must be somebody that can guide the couple aright. Then there is payment of sadaqah or dawah, which is known as the bride price. It is given by the bridegroom to his bride in accordance with their agreement, and it is paid in respect of the bride. There must be formal proposal and acceptance. So you see, this Islamic marriage shares some things with traditional customary marriage. Because there is proposal and acceptance, the family of the bridegroom will formally ask for the hand of the son, and the family of bride will formally agree. Then there must be two witnesses. The presence of these witnesses is necessary to validate the contract, and of course, the witnesses are preferably male. So that they want to show the seriousness of the occasion. Now, we don't want to rule out international influence on our marriage system. Apart from the fact that our laws are still in its revamping, there's something that is called double deck. It's a term used to describe a marriage, where a situation where a same couple celebrates marriage under more than a system of law. For example, most women wears 2 rings. Even myself wears 2 rings. And if you ask, they will say one is engagement ring, one is the marriage ring. So that double deck simply means that people that are married under the custom, they go ahead to marry under the act. But you see, some people, they will do nikah and they go ahead and marry under the act. And most of the time, it happens that a woman will want further security. Say, if I do traditional marriage now, tomorrow you bring another woman in. Oh, if I remain with nikah, you want to add to us until we are 4. So let the government be a witness. And they still go ahead and do permit me to use the word certification, so that they have certificates. Now, this double deck marriage has created some confusion, because the question would always arise whether the marriage is monogamous in nature or polygynous in nature, or both are existing together. There are 2 theories that have been propounded, made very popular by Margaret Tawonoka. There is a conversion theory which says that once you marry under the act, you have converted the traditional marriage to a statutory marriage. And there's also a coexistence theory that the 2 marriages are together. Well, the truth of the matter is that if there is no issue, most of the time, people don't revisit this issue. It's like a chosen action. When you buy shares, you may not see the shares with your naked eye. But when you need money and you sell the shares and it becomes an alert in your account, it becomes something tangible. So when we talk about double deck marriage, you find out that even people that have conducted traditional marriage and statutory marriage, they end up going to court for dissolution of marriage. Most of the time, they don't even bother with the traditional one. They will have done pack your load and go. They will have been separated. They will have fought. So the most important thing is that the certificate that they are holding in their hand, they want to nullify that certificate so that both of them will be free to go their own ways. Then we have a challenge in Nigeria. The challenge is child marriage. The Child Rights Act actually prohibits child marriage. And of course, there's punishment for people that are practicing it. The issue is an unsettled debate in Nigeria. And Section 29, subsection 4B of the Constitution introduced an element of ambiguity when a female that is considered old enough is allowed to renounce citizenship. I remember there was a time when this matter really went up in flames. But when we want to be reasonable, we know that child marriage will do more harm than any good for any community, because a child has the right to life, survival, and development. A child should be allowed to be a child. A child should be allowed to remain a child. A child should not be stifled. When you marry a child out early, you put your child, they put the child in a jeopardy. And that is why child marriage is a dangerous thing. And also the health challenges that follow, the reproductive and sexual rights infringement that follows will not make child marriage to be a desirable thing in Nigeria. Now, let me quickly talk about some misconceptions about marriage. I want to reiterate the fact that cohabitation, no matter how long or stable it is, it can never translate into marriage, except the requirements of a particular form of marriage, except the requirement is fulfilled or are fulfilled. So that, oh, we have lived together for 15 years. I've had all my children for him. He's going nowhere. It's my husband. He can go everywhere, except the man is married to you. Then marriage is not an engagement or a promise to marry. It is not an agreement of a future kind like betrothal. All this will, no matter how long standing, it does not confer marital status. So marriage is a definite, and that is why traditionally they want us to do it as it should be done. Statutorily, it should be done as properly. Then marriage is not a business or financial partnership. Sharing finance, running a business together does not amount to marriage. Yes, you have been running business together, you have 1 or 2 kids for yourself. It cannot translate into marriage if you are not married. It's either you are married or you are not married. So there are other misconceptions about marriage that when people say it, when there is a matter, they matchmakers and we are from the same town, because they might make you, have you married? Because they might make you are living together. You have to be married properly, whether customarily, whether under the act or through Islam. You have to be married properly. Now, I need to quickly also debunk this erroneous belief. People believe that once they go to church, they are married under the act. It cannot be a legal marriage except certain formalities that I've listed earlier have been followed. And this has been stated in the case of Obiekwe and Obiekwe, where they said that if you marry according to customary law without obtaining certificate under Marriage Act, you have just done church blessing. It does not add anything to any civil marriage, or it does not remove anything. So it's like decide to celebrate your marriage in a church and you did not file any notice at the registry. You don't have registrar certificate. You don't have anything. And you go to church, they pray for you. It's a very big church. It's the biggest church in the locality. All the bishops of your church are present. They poured oil on your head. It doesn't change the fact that you have just done traditional marriage. Except that church is a licensed place of worship. Except you have collected registered certificates, and you cannot collect registered certificates except the church is a licensed place of worship. And that is why some churches will go ahead and tell their members to do their registry marriage before they come for church blessing. Now, conclusively, we know that marriage is the most popular criterion for building a family. And of course, the future of the society is largely dependent on the ability to form and build healthy unions and partnership and promotion of other alternatives. So the sanctity of marriage is worldwide. So when we look at our look inward, we find that our marriages need to be revamped, the style. Let each law, there are countries, a country like Ghana, a country like Uganda, they have, you can marry under the act, you can do civil marriage, which is valid, which is registered. You can do Islamic marriage, valid, registered. You can do church marriage, valid, registered. You can do traditional marriage, valid, registered. They have those four under Ugandan law. And it's similar to what is happening in Ghana. Why not Nigeria? Why would we allow people to start thinking that? And you see, once we get all marriages registered, we have a central registry. When somebody is already married under the act or married to somebody else, it will be easy, very easy to trace. There was a particular matter of a man long time ago that happened in Oyo State. The man would target young, matured bank workers, bank officers, that are in their early 30s, mid 30s, that are already desperate for men to marry them. I target them, befriend them. Then the next thing will be, oh, my accommodation has issues. Collect money for accommodation. They will eventually, we take them to registry, they will marry. So he did one in Lagos, he did two in Ibadan, different registries, and did one in Ilorin. But the last one that he did in Ibadan was the second one. The lady suspected because of some of his phone calls. Before the lady discovered that they had a thriving family in Lagos with 4 children. The one in Ilorin had 2 children with that one. Then the one in Ibadan, they didn't have any child yet. And the lady filed. Of course, it was a case of bigamy. I sincerely don't know how it ended, but it was really quite interesting that time because it just shows that we just need to do something about our system if we are really, 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 if we really want to sanitize the society. I want to appreciate you for this opportunity. I want to hand over to the discussant to do justice to the little that I've put together on the different types of marriages that could be celebrated in Nigeria. Over to you, moderator. Thank you very much.
Very much, Professor Ma. Thank you very much, Professor, for that rich, comprehensive, and thought-provoking presentation. I believe your overview has set the stage for a rich discussion. I sincerely want to apologize to everyone for the technical challenges I experienced earlier. For our time, we will now proceed to the discussion segment of this webinar. We have with us 3 eminent discussants, each bringing valuable perspective from academia and legal practice. The discussion will revolve around 3 core questions aligned with today's theme. As earlier introduced, for our discussants, we have Professor Nasiru Tijani, who is here with us. I believe he has earlier been introduced. We also have Mrs. Nancy Obinwa and Mr. Abdul Warith Ibrahim. So my first question goes to our able professor, Professor Nasiru Tijani. Professor, sir, we just want you to please tell us what constitutes a valid marriage in Nigeria. Professor. Professor, the floor is yours. Over. Can anyone hear me?
Yes, Prof is here now.
Okay.
Prof, please,
Okay.
the floor is yours.
Okay. I was muted. Thank you very much.
Thank
Prof,
you, sir.
Thank you for that presentation. Good afternoon, distinguished colleagues. I think Prof has covered all the areas, but the validity of a marriage, I'll just take a few areas that may be challenging and is something that as practitioners we should know. One area is the distinction between a licensed place of worship where you can celebrate a valid marriage and the registry. Prof has mentioned this, two areas that you can celebrate a statutory marriage. It could either be a licensed place of worship or the registry. For the registry, we don't have any challenge because that is where the process starts. You file your notice of marriage and then you take your Form C and subsequently you come for the celebration of the marriage before the registrar. But what about a licensed place of worship as a place to celebrate a valid marriage? And this becomes very important because if you celebrate a marriage, not a licensed place, then what you have just done is to go for a church blessing rather than a statutory marriage. Now, the licensing of a place for a statutory marriage is done by the Minister of Interior. And it is the place of worship that is licensed. There's nothing like a general license of a place of marriage. For instance, if you say you belong to a denomination, a church, you can't say because our headquarters has a license to celebrate marriage, that license will cover everywhere. No. Individual premises for celebration of marriage must meet criteria that is set by the Ministry of Interior. And that is why the ministry will usually publish names of licensed places of worship. So if we are going to advise our clients or our friends, our family members, find out first, is it a licensed place of worship? They must be able to show you that this is a licensed place and the person that is going to celebrate the marriage is an ordained minister of that denomination. Let me give an example. If you say, well, I don't want to mention any denomination, say I belong to this, because our headquarters, you see people going there all the time. I'll say, oh, we can also do this here.
Oh, we lost him. Can anyone still hear Prof?
No, I think he dropped out. I'm sure he will reconnect.
Okay.
Prof is still on, but we cannot just.
Okay.
I'm sure he will.
Okay. Thank you very much. I was said. So the point that is being made is that we must be sure that it's a licensed place of worship. And it is the Ministry of Interior that will give the license of a place of worship. Now, what about the registry? There's a controversy between the local government and the federal government registry. Professor Olomola had mentioned that the marriage is in the exclusive legislative list. Now, does that mean that it is only the federal marriage registry that is recognized? This has been a challenge between the local governments and the federal marriage registry, the Ministry of Interior. There was a different judgments by the high courts showing that it is exclusive to the federal marriage registry. Some will say the local government can have the authority. the decision of the Court of Appeal in the cases now, especially the one that has to do with Ethiopia Minister of Interior, is that both the local government and the Federal Marriage Registry, they can coexist for the celebration of marriage. But the marriage, the Form E is the one that is supplied by the Ministry of Interior for them to use. So what is the point that is being made? Even as it has to do with marriage registry, you can go to a local government, but be sure that it is a Form E that is issued by the Ministry of Interior that is used in that place. So there's no exclusive right to the Federal Marriage Registry. You will have the Federal Marriage Registry, for instance, in Lagos here, in, I think it's in Alagbon Close now from Ikoyi. But you have the local governments. They can also celebrate marriages. And we can look at that authority. The Court of Appeal had the opportunity to go through this cases. It's a 2023 case, Ministry of Interior against Ethiopia's local governments, 2023 Law Pavilion. There are two different cases, but that is something that we need to look at and see what that position is. Another area that I want to emphasize is the question of Form E. Prof had mentioned it, but this Form E that we are talking about, you must be very sure that it is a Form E. Sometimes you see, even if it's a licensed place of worship, you see a cardboard with different names. That is not a Form E. So look at the precedent of Form E that constitutes a valid marriage certificate. Otherwise, what you are carrying about is not a marriage certificate. And when the issue of dissolution comes, it becomes invalid because it is not something that can be used. So that is something that is an advice that I want to talk about in the validity. This has to do with statutory marriages. I've mentioned who can.
Sorry, we've lost Prof again. Okay. Can someone still hear him? Okay. Can anyone still hear him?
Oh, I think it dropped off. I'm sure he's trying to connect.
Can you hear me now?
Yes, we can hear you now, Prof.
Please, I have another device that you can unmute. I have challenges with my network. All right, so I hope we got the point about Form E, the use of Form E. Can you hear me, please?
We can hear you, sir.
Can you hear me? Can you hear me? All right, thank you very much.
Yes, sir.
So
Yes.
that is, so we must be careful the Form E that we carry about, the marriage certificates. Another area that I want to talk about is the marriage district. The division of, you hear of marriage in this district. The summary of it is that now each local government is a marriage district in Nigeria. So you can celebrate a statutory marriage in those areas. So I think I will just leave that quickly and then go to another area. I've discussed the Form E. Now, in relation to customary marriages, Prof has discussed this. There is she has also mentioned something about double-decker marriage. But the area I want to talk about in customary marriage is what is called proxy marriage. There is what is called proxy marriage. And proxy marriage means that a marriage that is celebrated where the couple are not present. Please, I want you to note this. you cannot have a proxy marriage in a statutory marriage. There is no proxy marriage in a statutory marriage. That means you must appear before the registrar of marriages or the minister, the officiating minister in your licensed place of worship. But in a customary marriage, you can have a proxy marriage. And that is common today. You see pictures, they are placed in a place and say, these are a couple. One is in Canada, they are both in Canada, they are both in the UK. But the families are present. The consent of the parties, they ask, you want to marry this man? They will say yes. Even with modern technology, you can do video. And then the bride price is paid. There's a handover to the family of the groom, the handover from the bride's family to the groom's family. So I'm reiterating this part because proxy marriage is something that is common now. It is a valid way of celebrating customary marriage, not a statutory marriage. So if you see some people that would deceive you and say, oh,
Okay. We've lost him again. I think the network is not doing us good at this time. And because of our time, I think, can anyone hear Prof? Can anyone still hear him? Wow.
I'm sure he dropped off. I'm sure he will try and connect again.
Okay, then because of our time, I think, I don't know how we're going to do this, but I think we can move to the next discussant. But I want you to also agree with me that Prof has tried in doing justice to this particular question. He has highlighted the key elements and defined what constitutes a valid marriage in Nigeria. Do we have Prof back, or we should just move on?
Please move on.
Okay. I actually had a deep dive question for Prof.
Can you hear me now?
Prof, we can hear you,
Yes.
sir.
All right, so let me just round up and say that these are areas that we need to have in mind. Sometimes some who contract marriage, Islamic marriage, they go and do a marriage under the statutes. So you have an Islamic or a customary marriage, not to the same party, you go and do a statutory marriage. That is an area of conflict. Which of them will supersede? The clear position of the law is that you can only marry the same person under statutes where you had already married that person under customary law. There are conflicting, there's a recent case of Mohammed against Mohammed, but that is something we'll discuss in another session. But the point that is being made is that customary marriage to a party, it is only that person that you can marry under the statutes. So thank you very much. If there's any other question, then I can take them.
All right, once again, thank you, Prof. We really appreciate that explanation. And as said earlier on, I believe he has done justice to the question asked as to the question of a valid marriage in Nigeria. As earlier said, I had a follow-up question, but I think there will be no need for that, as I can see in the inbox that we have lined up of questions awaiting us from the participants. So quickly, I would like to move to our next discussant, Mrs. Nancy Obinwa. And your question reads, how do different marriage types intersect with law and cultural norms in Nigeria? How do different marriage types intersect with law and cultural norms in Nigeria? Over, ma. Thank you.
Thank you, Kambasha. And thank you, Professor Bolade for the presentation, and the discussion by Professor Nasiru has also been very insightful, laying all the foundations for me to do more or less work this afternoon. I thank every participant who is here. You're here because you have an interest in family law and the topic being discussed. I would continue from where Professor Nasiru stopped in terms of the importance of Form E, of a certificate to prove that there's been a marriage. Now, the customary marriage and Islamic marriage doesn't necessarily have to have the paperwork in contemplation. However, if anyone is interested in having their marriage documented, the law provides for an application to be made and for the marriage to be registered, and such a person will be issued a marriage certificate as if it was also a statutory marriage. They are different, but you will have a documentation to show for it. This is particularly important where there is plans of immigration. If I will use the UK, for instance, customary marriage under native law and custom is well recognized in the UK by the UK government. There is absolutely no need for anybody to falsify documents to prove that such a person is married under Islamic law or customary law. It would be tasking anyway to prove that marriage without a document, but then you do the work of doing that proof. If you want to, not have to make explanations of proving, then follow the right steps by making sure that you have it properly documented. In recent times, not too long ago, that was towards the ending of last year, a report was made about several forgeries emanating from Nigeria. A criminal investigation and trial concluded between 2019 and 2023 revealed that over 2,000 customary marriage certificates were fraudulently produced and presented as having been issued by the Agege Customary Court in Lagos. It tried to show that the applicants who wanted to use it had undergone a marriage ceremony according to the customary law of Nigeria. The jury found that those marriages never took place and that the certificates were forgeries. Now, what's the fate of such a person trying to prove relationship to gain immigration status in the UK? It will be a ban from ever applying for at least 10 years. So you see, it doesn't make sense if you have to forge anything. If you have plans of immigration, migration, speak to a solicitor. Get the legal guidance you need so that you're able to do things right. Something also important that I should mention in terms of validity of marriage. The marriage under the statute is as valid as the marriage under customary law. It's a matter of choice. Anyone that pertains to you, that you're interested in, just make sure, like the lead presenter has said, that you follow the laid down procedures for it. Having a living lover, living with somebody for so many years and not being married is not marriage. But if there is a customary marriage, hold your head high up that you have a marriage. And even where there are more than one wives, each of the marriage between the man and each of the wives is as valid and legal and holds for all intents and purposes. So far, the rites have been performed according to the custom of the person involved. Usually in Nigeria, it's the woman's custom. So the bride's custom, the way and manner in which women are given in marriage to men, so far it is observed to the letter, particularly that payment of bride price, regardless of how much it is. In my locality, I understand that I think it's about 2,000 naira or even less. So for some other people, it can be so high, but whatever it is, so far it is paid. There is the capacity to enter into that contract, and you have witnesses, and the ceremony is done the way it should be done. It's a valid marriage. It is not something anybody should be ashamed of. It is important to understand this. It's a valid marriage, and if you wanted a paper to prove it, go and make the necessary registration, the Ministry of Interior, and you'll be issued a certificate. There is absolutely no reason to fake or forge any documents. It wouldn't end well. Another important factor again is how these marriages intersect with law and culture. Yes, it's part of what I've said now. And a follow-up to that is, in this age and time, social media craze and people's desire to copy others, you want to have destination wedding, whatever you're doing, make sure it is legal. In whatever country you want to go and get married, it's important to ensure that you follow the procedures, whatever the law of that country stipulates as what is right to do, follow to the letter. Interestingly, the provision of the law, which allows for a Nigerian who wants to marry somebody else who's not Nigerian, or even two Nigerians who want to get married outside Nigeria, they can go to the diplomatic missions, the embassy of Nigeria. There is a registrar there who has the authority to join those parties together. But interestingly, I'm not sure I've seen that happen here in the UK, for instance. People who get together would rather follow the law of England, of UK, to do what they need to do and not consult the embassy to get married. It's a question of choice. Whatever you want to do, just make sure you do it right and everything will be okay. If you're such a person who wants me for mine, I don't want to share with anybody, you like the sound of, how is it said again? Know ye that by the public taking of each other as man and wife in the presence of these people as subsequent attestation, that all others are ruled out of the affair. You just want to, then you know you're thinking of statutory marriage. But if you have been married under customary law and you saw others who were there before you and you're all under customary marriage, then that is what it is. Hold your head high up and enjoy what you have. If you do not want to share, by all means, have the statutory marriage, and the law protects you that once that is done with you first, nothing else, nobody else can come in and be a sharer of what you have. If I would expand that further into the culture play with marriage, culture has come a long way in influencing marriage and relationships generally. The lead speaker rightly has stated that homosexuality, same-sex marriage is criminalized in Nigeria. In the UK, for instance, that was the law a while ago. It was illegal. But over the years, the culture of the people have detected that people of same sex can be married. And the law evolved, and there is civil partnership for people who are of same sex, and even people who don't want that word marriage. I don't know what scares some people in marriage. Or maybe it's a matter of choice. They simply don't want marriage. They want partnership. And so they have the civil partnership. And both marriage and civil partnership are duly recognized in the UK as legal and enjoy every support of the legal framework. So it's also a question of choice if you want a civil partnership or if you want a marriage. And the way of the solution is nearly the same, but different terminologies. And what would be the major difference? And the civil partnership, you don't have to go to church to get any blessing. You are married and you have your documentation to show for it. Now, another thing that has affected the way we do things in Nigeria is that Cinderella kind of dream, and every lady wants to wear the white dress, flowing gown, and have things elaborate. Just like the lead speaker has said, you could look beautiful, wear the best, call people, have a party, be in a church, and if the church is not a licensed place of worship, you just had a party and people just ate food, you are not married. I think we should not be carried away by things we see in the movies, reading the papers. And if we really do want marriage, to do it the right way and follow the law. People often don't feel very comfortable with just the traditional marriage. It's so valid. But if you want to put more on it, the double decker and even triple decker, however you want to fortify what you're doing, that's fine. But the bottom line would be that once there is a statutory marriage, it takes precedent of every other thing that has been done in terms of the solution of the marriage. I mean, it's the courts, only the courts that can dissolve the statutory marriage, unlike if it's a customary marriage. And once you've put that statutory marriage on the customary marriage, even if you return the bride price, you are still married until the court pronounces the other nisi and then the other absolute. But today we are not discussing the solution, we're still discussing marriage. So I will leave it at that. Should I say finally, in terms of how culture influences what we do in marriage, and if I'll go further with how it affects women, rights of women, rights of children. Like I earlier said, the validity of customary marriage should not be downplayed. And culture has changed a lot of things over time. Before now, to dissolve, I keep going to dissolve because the foundation you lay would affect how things eventually would be put aside if things go south. So it's important to know how you are building and know how you will get off it. Culture will continue to shape the way we do the things we do, but the law still remains supreme, and we shouldn't get carried away by the things we see other people do. You don't know the full story. Make sure that whatever you're doing in your relationship with anybody, that you have your documentations right. Without it, it will be a very sorry story. So I want to believe I've answered the question as it relates to how it intersects with law and cultural norms in Nigeria.
Okay. Thank you very much, Madam Nancy, for that analysis. You've clearly shown how culture are intertwined in our marriage system. But on a quick note, I'm sure you've answered that, but I just want to buttress it a bit to say that it means I just want to dive into a big question for you, which also said, how should the law respond where cultural practices conflict with constitutional principles, particularly in areas such as women's rights, consent, and equality within marriage? In other words, should culture evolve with the law, or should the law adapt to cultural realities? Just in few seconds, I believe you'll be able to put an answer to that before we move to our next discussant. Thank you, ma'am. Mrs. Nancy?
Yes, okay, thank you.
Okay.
So the thing is, culture, everybody holds very tightly to their culture, but when it comes to the law, whatever culture you have, it will allow people to simply get on with how things have always been. Change is constant. Some things would change and shift the dynamics. So the law needs to evolve. Just like we talked about same-sex marriage. It wasn't a thing before, but now in some countries it is, and in some countries it's criminalized. So to that extent, the law will evolve, but culture must not dictate everything. Otherwise, we will stay back and we will not move forward. So it's important that the law moves, evolves with the people's way of thinking, ways of doing things. And in terms of women and women's rights, I think the culture is shifting a lot. Before now, the man bears all responsibilities in terms of finances, but we know things are changing, and women who are financially stable in marriage make their contributions so that when things do go south, whether they've made contributions or not, the law has continued to change to determine that childcare and home management can equal to financial contribution in some way. And so there is the shift in not apportioning anything to the wife, who often doesn't have the financial muscles, to making it based on what can be seen that the woman has contributed in the marriage in whatever way. It mustn't be finances. So culture keeps shifting. And for the Constitution, our Constitution has played a bit of a silent part in terms of age. So many things have been left neither here nor there. But with the Child Rights Act, we know the minor is below 18. So for consent in marriage, it can be a bit argumentative based on the different sectors in Nigeria. Child marriage, it doesn't help the society, but for each region, they have their various laws, and that's why customary law is based on whatever the states and the various customs of the people are saying to them. But once it's under the Act, 21 has been stated to be the age at which you don't need consent of anybody. But whether a particular age has been also been stated there, like the lead speaker has said, it's not clear. But if we will go with the Child Rights Act, then we would know for certain that anybody below the age of 18 is a minor. And there is no need seeking consent of whatever kind in terms of marriage. I think that would be my answer to that.
Okay, thank you very much for that perspective. We've now examined marriage from the lenses of validity, consent, and cultural interaction. I would like to zoom out and look at the broader social consequences of our marriage system. And right away, I will be calling on our third and the last discussant in the person of Mr. Abdul Warit. My next question is directed to you, sir. Welcome on board, sir. Mr. Warit, Abdul
Thank you very
Warit
much,
Ibrahim.
Miss Ambasha, for the
Thank you,
question.
sir.
I don't know if you can hear me.
Once again for coming. My question is, what are the implications of Nigeria's marriage system for individuals, families, and society at large? And we have less than 10 minutes to do this, so we dive into the questions and answer.
Yeah, thank you very much for the question. I would like to thank the previous speakers, Professor Omolola and Professor Tijani, for making my job quite easy and short, and also Nancy for also speaking extensively on part of my question particularly. I think Nigeria operates a multifaceted system comprising of statutory marriage, which is governed by the Marriage Act. We have the custom marriage governed by people's traditions, and also Islamic marriage governed by Sharia. This pluralism reflects our cultural and social diversity and all. I believe this system encourages marriage. Someone cannot come later and say that, okay, the laws in the country have prevented me from marriage, from marrying someone I love. So the law is expansive. Whatever decision you choose, whatever system you choose to marry, it provides for. If you want to choose the statutory system, it provides for it under the Marriage Act. You want to use your traditions, you're a traditional person, you can marry under the customary law. And also if you're a Muslim and you want to marry under the Islamic law, it also permits it. It also allows for it. For example, for individuals, those that prefer the Marriage Act, I think it's more beneficial for those that want the nuclear marriage, that are singular in nature, that just want to say, me and my man. As most of the speakers have said, once you marry under the statutory act, the Marriage Act, you can only marry one person. I think there's a general misunderstanding from people whereby they marry one person under the act and then they say, okay, let me go and marry the second person, customary law. It's just a general advice which people should also give their clients, that marriage is void. So which will later bring on issues in the particular to statutory and estate planning, whereby you have married someone firstly under the statutory law, and then you're also marrying someone under the customary law and the Islamic law. So many people usually do this just because I think there's Japa syndrome, whereby people they'll follow the customary traditional marriage, and also they'll also do the statutory marriage to marry under the act just to make their marriage legitimate. But then, as Professor Tijani has pointed out, you can also marry under the Islamic law, and then you can register your marriage, which gives you the license. I think for under the Islamic law, you can marry, I was checking it, you can register your marriage under the Islamic Marriage Registry Unit in the Sharia Court of Appeal. And also for the customary law, you can register it under the area courts or customary courts. So I think most people should be advised to follow this. At the family or individual level, each system has what it promotes. Statutory marriage usually promotes the nuclear family, whereby the customary and Islamic law promote family as an institute, that the extended family as a marriage institute. For example, whereby someone wants to marry someone, a person wants to marry another person for consent, for example, under the statutory marriage, the consent needed is just for the individuals, whereby the potential husband, potential wife say that, okay, I like you, let's get married. The law just requires their consent, whereby if they're of age, it's valid. But alternatively, under the customary law and then the Islamic law, everybody knows one has to do the introduction, whereby family members meet and then they do the first introduction, the families intertwine. If they gel, then they go to the next stage, whereby consent of the family members are also required for the marriage. I think for Islam, the wali is the one that actually gives out the bride, and not the bride that gives out herself. So it promotes the extended family unity and integrates both families, whereby for the statutory marriage, just promotes the nuclear family. And also, for instance, touching briefly on the aspect of divorce, I think the Marriage Act is one who says like a jealous spouse, in the sense that the Marriage Act and the Matrimonial Causes Act says that I think it believes that once you're married, you are locked into the marriage. You can't come back and say, no, I don't like this person, and then divorce the person. So you just have to, there are steps and guidelines which were very strenuous per se, that you have to follow to be able to dissolve your marriage. I think the Family Law Committee will be doing like a number of series detailing divorce, estate planning, and all. So I think you should stay tuned and also follow the committee for subsequent engagement to understand the entire marriage institute, because marriage as it is not just marrying somebody. It determines a lot of things. It determines the relationship of your children, it determines your estate, it determines the rights, it determines your spousal rights. There are a lot of things that just boil down to the particular marriage systems you choose to wed under. So, for example, let's say, as I've said earlier, statutory marriage doesn't allow you marrying multiple persons. I think it's termed as bigamy under statutory marriage, which is punishable by 5 years, and then wherever you marry, the marriage is void. So it gives the person a lot of headache, whereby you want to, when the person has died and they want to share the estate, you now start thinking, okay, this person married on that, because most people usually do the double-decker system, as spoken to by Professor Olomola, that many people do the double-decker marriage, whereby they marry under the act and then they do the traditional wedding and then they live their lives as, let's say, Muslim or traditionalists. So you have a lot of, it boils down to majorly 3 systems, whereby you don't know which one to pick. And then the laws are, I think the law is going based on the statutory law part, the judicial law part, whereby the courts are determining a lot of cases, and hopefully it gives a leeway whereby it gives a clear direction, whereby if you do this, this is the step that will be taken by the courts. I think Professor Nasir spoke about the case in Muhammad versus Muhammad, which will be spoken about in detail in subsequent sessions by the committee. At the societal level, let's say the plural marriage systems which Nigeria operates, it promotes inclusivity, and then it protects the marriage institute, whereby whichever aspect you choose to fall under, it allows you to fall under, and then all of them are greatly valued. Thank you very much.
Okay, thank you, Mr. Abdulwarit, for that broad and insightful overview. Let me push this a little bit further with a follow-up question, which is considering the rising rates of divorce, inheritance disputes, and family breakdowns, do you think Nigerians' plural marriage systems strengthens family stability, or do they create uncertainty that the law has yet to adequately address?
Okay, I think they both do.
Or will you say the challenges lies more in the multiplicity of systems, or in weak enforcement and legal literacy?
Okay, I think they both do this. The uncertainty is growing stronger than the stability, whereby historically customary law and Islamic law were embedded within strong social enforcement mechanism, whereby the family elders, religious authorities, and community norms enforce the law. And also at the same time, statutory marriage, while legally clearer, has not fully internalized socially. Many couples comply with the form of statutory marriage, like I said earlier, but then they operate customary expectations, especially around property ownership, gender roles, and succession. This mismatch fuels divorce litigations.
Can you hear me?
Yes, I can hear you. I don't know if you can hear me.
Can anyone hear me?
Yeah, we can hear you. I think I had your question. I'm trying to answer the question. I don't know if you can. If the audience can hear me.
Can you hear me?
Yes, we can hear
Yes, we can hear you.
We can hear you.
Okay.
Yes, just to continue, the law unfortunately has not kept
Can anyone hear me?
Yes, we can hear you. Unfortunately, law has not kept pace. We still see that still unclear transitions between the marriage systems, whereby people choose two different marriage systems fall under inconsistency with judicial outcomes in succession and matrimonial causes. And generally, there's just a poor public understanding of the impacts of whatever marriage system you choose, whereby people still do both and then still expect the best outcome. So many people usually do forum shopping and then they expect the best outcome for it. I think just based on my opinion, I think the Marriage Act needs to be, it's an old law which was brought into Nigeria. It needs to be amended just because it stifles the divorce rate. There are a lot of people who are unhappy in their marriages, and then they have to, the old law also provides that you guys can't connive to end your marriage. It just has to be a legal reason for you to end your marriage, which has to be determined by the court itself, not by you, the party. So I just think the Marriage Act needs to be amended just to clear some uncertainties in the space of the marriages, because I think Zoran that's lacking. Customary law is usually imposed based on, it's usually based, if it's not repugnant, it's allowed, and the Islamic law provides generally for all the problems of marriage. Thank you very much.
Okay.
I don't know
Thank
if
you very much,
yes.
Mr. Abdulwarit, for that insightful explanation. And I want to say a very big thank you to all our discussants for their insightful, engaging, and thought-provoking contributions. The depth and diversity of perspectives shared today underscore the complexity of marriage regulation in Nigeria and the importance of continuous dialogue among legal practitioners, academics, and policymakers. At this point, we will proceed to the interactive question and answer session, where participants will have opportunity to ask questions and share brief comments. So at this point, I would like to call on my other colleagues, Hugo and Christopher, to take over the session. Thank you. Kindly keep your question brief, don't forget. Direct to the discussant and limited to one question, please. Thank you. All right, okay. Thank you.
You can unmute yourself now. You can unmute yourself now.
Hello, good evening.
Yeah,
Good
Ugochi,
evening.
you can now unmute yourself. You
Good
can
evening.
unmute
My name
yourself.
is
Right.
Henry.
Thank you so much, Prof. And thank you to our our discussants, as well as the moderator, Kambasha. I'll just go straight to the questions now. And so I'll be asking, the first question goes like this. So where the church does not return the certificate, the marriage certificate, to the Federal Ministry of the Interiors, does it mean that the marriage is invalid? This question was asked by Bumi Ibrahim. And I think Prof will be in the best position to answer this question.
Thank you. Ordinarily, it is the people that will that got married that will take a copy to the marriage registry. So the church would have custody of one, and you'll be given to one for you to remit to the registry where the notice of marriage was filed. So it is for the parties to ensure that the certificate is submitted there, because in case of any issue in the future, you usually go back to the registry to ask.
My phone on whatever, even at the meeting. So that
hello, please, if you're not speaking, can you mute yourself?
I've been waiting for.
So I was saying that it's for the parties to make sure they remit that copy. But if inadvertently they do not remit a copy to the marriage registry, the only thing he can do is that he can render the marriage voidable, not void, because except they have issues. Except they have issues and the certificate cannot be traceable. But if the certificate can be traceable, then there is no issue. But remission to the marriage registry is for record purposes, to see that the marriage was properly conducted and the proper certificate had been issued, and it's usually in triplicate, like I said, a copy to the couple, a copy retained by the church, then a copy at the registry. But if the marriage was conducted at the registry, this story will not come up because the party will just be given a copy of their own. Thank you.
Thank you so much for that very exhaustive response. So I'll be moving on to the second question. What are the elements of same-sex marriage? Mr. Michael Chuku is the one asking what the elements of same-sex marriage are. And I'll still call on Prof to continue to answer this question.
Without much ado, number one, we don't even need the elements, but the law stipulates that amorous affection with the same sex, amorous relationship with the same sex, although the interpretation section of the law itself contains 9 sections. The interpretation section did not really go into the explanation of these amorous affairs. But the truth of the matter is that the law enforcement agents at the outset, has made a lot of arrests, saying that people were involved. But anything that looks like abnormal relationship between people of the same sex, of course, will be an amorous thing. And of course, you know that you cannot even conduct a marriage. So if James and John were married in Netherlands, when they get to Nigeria, they will become brothers, because that marriage will not be recognized in Nigeria. So element is that two people of the same sex they want to come together, and it is not permitted under our law. Thank you.
Thank you so much. Same-sex marriage is not permitted under our law. If you try it outside, you become siblings when you come home. All right, so next question. I think Prof would also be in the best position to answer this question. And it says, what is the difference between dowry and bride price?
Well, most of the time, we loosely refer to bride price as dowry, but dowry is actually bridal wealth, and is very common in India, when a family of a bride that is getting married to a man prepares wealth for her that is taken to her husband's house. But bride price is actually what we practice in this jurisdiction. In Nigeria, is bride price that is given to the family of the bride. So, but when they use the word dowry, I don't know the history behind it, I must confess, but they just use the term loosely, dowry. But the truth of the matter is that one is gifts to from the family of the bride to the bride going to husband's house, and the other one is the gift from groom's family to the bride's family, with respect to their daughter. Of course, the daughter is not on sale. It's just a love gift to show that they appreciate the daughter.
Okay, thank you for that clear distinction, Prof. I would also like to ask you, on behalf of C. Daniel, can marriage under Nikai replace statutory marriage?
No, because they do not have the same, just like Professor Tijani said, it cannot replace it because they have different incidents, they have different requirements. So, like Nikai, a person married that has conducted Nikai, it can marry up to 4. But once you conduct a statutory marriage, you stick with that only one person. So it cannot, and that's why we said different systems of law with different things that are associated and consequences that follows it. So you need to unmute yourself.
All right, thank you, Prof. I would like to draw the attention of the people who have raised their hands to indicate that they have questions and comments. Please feel free to state them, put them in the chat box so that we can, for want of time, we can just read them out. And Professor Tijani, please, I would like to direct this question to you. So if a female is a witness during the Islamic marriage, does it not show seriousness? Please kindly provide the law that says only males should witness an Islamic marriage to show seriousness. Dr. Endwell Chinda is asking.
Well, I don't know about that. Whether it has a female. I know that the process of Islamic marriage is usually done by male. And these are things that are done, the handover, the token that is made. And that is what Prof had mentioned. But that a female will be a witness to an Islamic marriage, not to my knowledge. And because of the nature of Islamic marriage, it's usually, most times you don't find females seated where the ceremony is taking place. That is the handover and also the bride price. They can only be maybe when the issue of the entertainment part, but the core part of it, I'm not aware that the female would be present in that situation.
Okay, and that would mean that there's no such law to show seriousness.
Not to my knowledge.
Yes, this is noted. Thank you, Prof. Question number 6. Question number 6. Can you mute yourself, Mr. Muhammad Abdullah? Thank you. Kindly address the issue of children arising from cohabitation. I would like to still call on you, Professor Tijani. Kindly address the issue of children arising from cohabitation without valid marriage. What is their legal status, since there is nothing like illegitimate child in Nigeria? Christopher Nwowu is asking.
It's true there's no illegitimate child in Nigeria, but under customary law, where the parties are not married under customary law, the child belongs to the woman. So the custody will be with the woman. It is when you have paid the bride price that you can claim anything in relation to that, in relation to the children. So the law is that children born out of wedlock in a customary marriage, well, let's say children born out of wedlock, there's no illegitimate children, but the custody will be with the mother of those children.
Thank you very much, Prof. And if I heard you clearly, I heard you say that unless bride price is paid, can the father of the child claim the child? But I would like to ask further, sir. Is it possible that where the man doesn't want to marry the mother of the child, he can still claim his child without having to pay bride price?
It will, of course, is the father of the children, so they can also bear his name. But when it has to do with custody, it will be an arrangement between the man and the woman. In actual fact, you find that those that are not married, they sometimes bear the name of their mothers as their surnames because of that, and that is the custom, depending on which area you come from. So, of course, arrangements can be made in future and say, oh, come and take responsibility for the child you fathered and all of that. But that is an arrangement that will be made between the man and also the mother of the children.
Thank you very much. Yes, please, you can add.
So I think that's why, for instance, the family court is there. There must not be a relationship between a father and a mother for a child to be catered for. So in any situation at all, for the well-being of that child, the courts are there for applications to be made for that child to be taken care of. And again, on the issue of culture and the law, things have improved now that we have DNA testing in case there is an issue of paternity. we can be sure of who is the father and let the father be responsible for the child. As always, it's always the mother who knows the father of her child. But in doubt, DNA testing would answer the question. Thank you.
All right. Thank you so much, Mrs. Nancy. I would also like you to answer the next question, and it is on partnership, which many have reasoned recently has been recognized as a type of marriage, especially after having lived together for many years. They have children, and everyone sees and believes that they are married, even though they are not in reality married. It's just a cohabitation. Please, ma, is it a legal position today? Thank you so much for your presentation. And this is Victoria Johnson Awa speaking or asking. Yeah.
Okay. Like we've all heard in today's presentation, it doesn't matter how long you have lived with a person. If what needs to be done is not done, it's not marriage. Marriage is not a business transaction, like the late speaker was saying, but it can be a partnership. And I think that's what it should be. Whether we have senior partners, junior partners, it's a partnership. There is the coming together and working together. And it's important we make it formalized, we make it legal. If you want me and you alone, marriage. But if it is a customary marriage, it's as valid. Just follow the native law and custom and have a marriage that is valid.
Thank you so much, Mrs. Please, can you mute yourself, Kodro? Thank you. Moving on, I would like to now ask, what are the legal implications of marrying two women under the customary law and going forward to marry the second woman under the Act? So is he married to the second woman under the customary law and the Act? I think, Prof, I'll direct this question to you.
Thank you, Gochi.
You're
the
welcome.
first thing is that the person lacks the capacity to be able to contract a legal, as in a statutory marriage with the second person, because except he wants to divorce the previous woman. If not, he doesn't have, and if he manipulates the system to do it, that marriage is a nullity, ab initio, because he will not be able to fulfill the requirements of the law with regard to statutory marriage, except maybe he wants to stick with the first wife and marry that wife under the statute. Otherwise, he would have to divorce and have that single status before getting married to another person under the Act. However, if he wants to marry under customary law, he is entitled to marry as many as possible. But if it is under Islamic marriage, he can only marry a maximum of 4.
Okay, thank you so much for the clarification, Prof. I would also like to ask Professor the next question. Can a mosque be silenced as can a mosque be licensed as a licensed place of worship for the purpose of conducting statutory marriage? Or is it that the provision is exclusively applicable to churches? Mr. Shetima is asking.
Okay, is that for me?
Yes, sir. Yes, sir, it's for you.
Yes, no, you license a mosque, statutory marriage. The law is that is the church that will be licensed, because even those who are going to conduct the marriage, they must be ministers so recognized in that particular denomination. So a mosque cannot be licensed to conduct a statutory marriage. It's opposite, because Islamic marriage is different from statutory marriage.
Okay, thank you so much. And I would further question, are the licensing of places of contracting marriages renewable or perpetual?
It's not perpetual, it's renewable yearly. The fees are, yes, you have fees that you pay to Ministry of Interior, and inspections are done to see that you are complying. Because if you don't renew, you won't have the bundle of the marriage certificate that you will use. So it's renewable yearly.
All right. Thank you so much, Professor Tijani, for that excellent. I'll now hand over to the moderator, Ms. Kambasha, to bring us to a close. Over to you, Kambasha.
Kambasha, unmute and bring it to a close, please. Are you on call?
You still have on call.
Okay, Nancy, would you just wrap up for us?
Okay. All right. I want to say a big thank you to everyone who's been here from the start to now. That's 2 good hours given to SLP. And we say thank you very much for tuning in, and we hope you have gained something. And we'll encourage you to watch the space because there is more coming. To our section chair, the Leonard Silk, Mrs. Falashade Ali, thank you for that remark and for spending this time with us. Thank you to the chairperson of the committee, Professor Omalade. Thank you, our able discussants, and our moderator. We'll blame it on the technical glitch because I know that there was very good preparation for today. And I want to believe that we've all had a good time listening, learning, and sharing. And we ask that you keep it this with us again when we have our next webinar. Thank you so very much, and God bless.
Thank you very much. Bye-bye.
Oh, sorry, Madam Prof. Before we go, will the recording be made available for us?
Yeah,
Thank you so much.
Now it's clearing. Now it's clearing.
Thank you so much. We really appreciate, ma.
Thank you. Thank you.
Thank
This is
you.
wonderful.
Bye now.
Thank
you.
Grateful. Thank you.
It was very impactful.
Prof, we are
Prof,
grateful.
will the recording be made
Thank you.
available to us?
Thank you
Well,
very
we will
much.
clarify with Secretariat.
Thank you so much. That
Thank
was
you
a
so much.
Thank you.
Thank
thank you
you.
so much.
How do you get our
Thank
attendance?
you.
How do you get the
We are
attendance?
grateful, Prof.
Bye.
Thank you.
Bye.
How do you get the attendance?
Okay, sir. The attendance is already on record. We have your name and
Thank
your
you.
name.
Okay, thank
After
you.
we have registered, we have recorded.
Organizers, well
Okay,
done.
thank you.
Kudos to
Thank
organizers.
you.
This is
To
very
all the
good. This is a very good
organizers.
session.
We are
God bless you.
grateful.
We appreciate.
We are very grateful. We
I'm
We
very
can still
grateful.
repeat
Thank
it
you
Thank
at
you,
some
our
other time. Continue to
moderators.
refresh our memory.
Bye-bye.
Marriages are
you
very
very
important.
much.
Thank you. Thank you.
We are
Okay,
grateful. We are
Kiara,
grateful.
Thank
you
you.
did a good job.
Thank you.
Thank you. Thank
Thank
you.
you.
You
Thank
did a
you.
good job.
Thank
Well
you.
done.
Kudos.
Thank you so much.
Thumb up for you.
Thank you. Thank you so much.
Thank you so much.
Thank you.
Thank you.